All right, hello everyone. My name is Justin Stivers. I'm the owner of the Probate law firm. We're based out of Miami, Florida, but we operate throughout the entire state of Florida. And this course is kind of a shorter version of one that I was teaching called Probate 101 for Realtors. And so we started teaching this course a while ago. I recognize, I think some people maybe have heard this before. I recognize some of the people names and faces on this call, but started doing this because probate in Florida is becoming more and more popular, or more and more necessary, as baby boomers, aging population starts to pass away. And I noticed that realtors are coming across probates more and more, either from representing a buyer or possibly representing a seller. And so this course, it's okay if you're not even sure what the word probate means. We're going to go over all of that. But the course is really designed to help you all identify when a property may or may not have to go through the probate process, give you enough information to speak intelligently with your prospective client, with your whoever you're working with, so that you can really stand out from your competition. Because there's no secret, there's a lot of realtors out there, just as there are a lot of attorneys. And so, try to find ways to really kind of help you stand out from your competition. And then if we have time, we'll talk a little bit about the how to market and how to find probate properties, right? Because at the end of the day, you all are probably interested about how to get listings and find more deals as well. So that's a little bit, that's kind of big picture what we're going to talk about. Again, my name Justin Stivers, the probate law firm. Our website is probatefirm.com, and you can get more information on us there, www.probatefirm.com. So, all right, well, let's just talk real quick, and just kind of some key definitions that I think would be good for you all to know. Probably the first one is probate. So what is even probate? Probate occurs after somebody has passed away. So we're not, I think, we will talk a little bit about wills and a little bit about trusts, but really that all occurs before somebody passes away. That's planning before they die. Probate is actually a legal process, a court process that occurs after somebody has died. And so for you all as a realtor, when that really comes into play is most commonly with real estate, right? Someone owns a piece of property, they pass away, and now their heirs, their children, their beneficiaries want to sell the property, or just get the property put in their name. Maybe they want to rent it or whatnot. And so probate occurs, again, from the real estate side of things. We go to court. We'll talk about how long it takes, but at the end of the process, the judge is going to say now who the owners of that property is. So that's really, when you hear the word probate, that's what it actually means. It actually means a court process. There's a judge involved, there's an attorney involved, and the judge is deciding who's going to get what of a person's things. Estate, E-S-T-A-T-E, estate, that refers to all of a person's things after they pass away. So while a person, let's just say John, while John is alive, he has his house, he has his car, his clothes, his jewelry, his money, whatever that is, that's just John's stuff. After John passes away, we refer to him and all of his things as the estate of John. And that's just how we're going to refer to it. So you'll probably hear me say the word estate, or even in your working with clients who need probate, we're going to be talking about, you'll hear the word estate. Last will and testament, we're going to talk a little bit about that. What is a will? So a will is essentially writing down someone's wishes, who they want to leave their things to. That's basically what it is. And one thing that we'll talk about, but just off the bat, is having a will does not avoid probate. And that's one of the big misconceptions I think out there is someone does a will, they say, hey, I want my daughter to get my property. that person dies, and then she finds out, the daughter finds out that she's going to have to go through probate. So we'll talk about ways to avoid probate, but generally speaking, just because you have a will, you're still going to have to go through the probate process. Probably the most important definition and term for you all to know is the personal representative. That's also, some states use the term executor, some states use the term administrator, but ultimately Florida, we use the term personal representative. And that's the person that you all, as the realtor, will be working with, who's going to sell the property, right? That's, if I'm representing the estate, the personal representative is going to hire me, and the personal representative is going to hire you as the realtor. And this is very, very important, because the personal representative is the only person authorized to sign any listing agreement, to sign any contract, to sign most of the, probably going to be the person signing the closing documents and everything. And so we'll talk more about that. But the personal representative, that's really the person who kind of controls the show and really does most of the work, and would be working with you and would be working with us. So those are, probably the main things. There's a bunch of other, but just for time's sake, those are probably the most important ones. All right, so let's dive right in and talk about, part 1 of 3. Let's talk about how to determine when probate is necessary, because that's really a huge issue. A huge thing that I see is that a lot of realtors, frankly, a lot of attorneys as well. I got an email earlier today. They didn't know that, from another attorney. They didn't know that probate needed to happen. And so, how can you know, without? I would never encourage you to practice law unless you're an attorney. But how can you all know whether or not probate may or may not be necessary? Well, if someone calls you and they say, "Hey, my mom owned this piece of property and my mom just died," right, that's probably going to be a good indication that probate might be necessary. But a lot of times that's probably not going to be the case. You might be working with a buyer and they want to purchase a property and they don't even know that the person passed away, or you might be working with a seller and they just mistakenly think that they automatically get to sell the property. So what we're going to do is I'm going to share my screen with you all and just give you 3 different examples of how we can identify. All right. So this is the first one. And for those of you that are just listening, I'll send these documents in the email as well. But really, all we're looking at is a printout from the Miami-Dade Property Appraisers website. And this first one, if we look here under owner, it shows Maria Pichardo, EST of. And so I mentioned that word estate earlier. And so that's what this stands for here, EST. Sometimes you're going to see that on the Property Appraiser's website. It's a good chance, I would say 99.9% chance, if you ever are looking at a property on the tax roll on the Property Appraiser's website and you see that EST of, 99.9% chance that this property, before it can be sold, has to go through probate. Now the probate might already be started, right? So it could already be started, and in that case, your attorney or someone would have to look through the court records to see. But if you see that before this property could ever be sold, this property would have to go through probate. So what happened here is Maria Pichardo died. She was the previous owner. So she was the previous owner of this property. And so her daughter wanted to sell the property. And before she could do that, she had to go through the probate process and have the property transferred into her name. So this was done quite some time ago, a little over a year ago. So if you were to go look at this property now, the owner would have been changed. It's no longer going to show Maria Pichardo, EST of. But her daughter could not sell the property, could not do anything with the property until the probate process was done. This is the most common thing that you'll see. This is the most common situation that you'll see. Now, one question I get asked a lot is, well, when does that EST of show up? When does the county make that change? And the honest answer is I don't really know. The county claims that they get the death certificate sometimes, and when they get the death certificate from the Florida government agency called Vital Statistics that records the death certificate, sometimes they make that change themselves. But I've seen properties where the owner died 5, 6, 7 years ago, and it still doesn't show that EST of on there. I think a lot of times what happens is a client will, so this is maybe a little advanced somewhat, but if the person who was living, or the person who died was getting the homestead exemption, meaning they were getting a tax break because it was their primary residence, the person inheriting it, if they're living in the house, they want to get the homestead exemption as well. But in order to get the homestead exemption, they have to go and change and get the property put into their name. So they mistakenly go to the county and they say, look, my mom died. I'm living in the house. Look, it's on my driver's license. Can you put the property in my name? And the county says, nope, you need to go through probate. And because your mom died, now you're not going to get the homestead exemption until the property gets put in your name. So sometimes people, I think when they notify the county, that's also how the property gets put into their name as well. So this is the most simple and most common. If you see this EST of, you're going to know that probate's necessary. Okay, second example. Okay, here under the owner, we have Jesus Silva EST of, and we have Maida Silva. Now, we just talked about that EST of stands for estate of. So in this case, Jesus and Maida, Jesus was the father, he passed away, Maida was the daughter. This was an investment property. They own this property 50-50, and we'll talk a little bit about different types of ownership and the way they own the property. But in this specific instance, they own the property 50-50 as tenants in common. And what that means is Jesus owned 50% and Maida owned 50%, and that's it. So Jesus died. Maida thought she inherited the property because she's the only daughter. Jesus was widowed. His wife had passed away. There were no other heirs, no other children. So Maida just assumed that she was going to inherit the property. She gets a realtor. They list the property. They go to closing. You know, they get a contract. They go to closing, and the title agent says, "Did you do a probate for Jesus?" And the realtor and Maida says, "No, we don't need to because I'm the only daughter, et cetera, et cetera." And you can guess what happened. The closing agent said, "You've got to do a probate for Jesus." Rightfully so. Maida's quite upset, and then they have to go through the probate process. And so what happened here again is relatively common, where intuitively you would think that Maida would just automatically inherit the property because it's her dad and she's already on title. But the way that they own the property means it did not pass automatically to her. So something you've got to really be careful of. So they just own the property. I don't have a copy of the actual deed, but it probably would have said something like Jesus Silva, a single man, and Maida Silva, a single woman. And that's all that the deed would have said. Now they could have avoided that, and it could have passed automatically to Maida when Jesus died if they would have owned the property in a way that's called joint tenants with right of survivorship. Okay, pretty common. Most of you all are probably familiar with that. And so what joint tenants with right of survivorship means is the title itself would have read Jesus Silva, a single man, and Maida Silva, a single woman, with joint tenants of right of survivorship. And if that was on that deed, something very simple, when Jesus died, that means his 50% would have passed automatically to Maida, and she would not have had to have done the probate. She would have owned the property outright and she could have sold it. Or if Jesus was still alive and Maida passed away, her 50% would have passed to Jesus, and he would not have had to have done a probate. So it's a very simple thing, and if it's done correctly, what you'll see is on the property appraiser's website itself, it will list the owner's name, and it's probably going to have the initials JTWOS, standing for joint tenants with right of survivorship. That would appear on the property appraiser's website itself. So that's very simple to do. Usually your real estate title attorney, closing company, something like that, they would put that on there. So it's something that is a good thing to do. A lot of people, the downside of it though is, let's say that Jesus and Maida, all of a sudden, maybe Jesus does not want to own that property with Maida. He can't take her off of the deed unless she wants to be taken off of the deed. So that's one of the downsides as owning the property of joint tenants with right of survivorship. There's other types of deeds as well. I don't want to get, just for time's sake, if you go to our website, I think under the blog, we have one titled Ladybird Deed. And so that's another type of deed that you can use to avoid probate. And so in that case, what you would do is the owner would say, I'm the owner, but when I pass away, I want the property to go to my son or whatever. And that's great. That's a good option, because if it's done correctly, if it's got certain language on there, that means when that person dies, the property automatically goes to the son, and the son does not have to do probate. He just automatically inherits the property. Very simple. But if the dad, let's say, 5 years later, decides he doesn't really like the son or doesn't like his spouse or whatever, he can take the son off of the deed, and that's fine. The son you don't need his consent to take him off of the deed. Whereas if you own the property as joint tenants with right of survivorship, you're 50-50. Unless that other person wants to give you or sell you their part, there's nothing you can do. So Ladybird deeds, the legal term is enhanced life estate deed. That's the legal term. The kind of term we use here is Ladybird deed. So enhanced life estate deed, and there's a bunch of other, there's several other types of deeds that you can do. The one other thing I wanted to show you all though about how you can avoid probate is by doing what's called a trust. So I mentioned earlier that a will does not avoid probate, and a will, what that is, end of wishes, who you want to leave your stuff to ultimately. But a trust, same thing, same concept. A trust is going to say, who you want to get your stuff. But the difference is, if done properly, it can avoid probate. So last example here. So you've got the trust, okay? You have the trust document. That's just, a stack of papers that says, who's going to get what. If you own a piece of real estate though, and let's say that you already own the real estate before you do the trust. So in this case, I think it's not going to show, but in this case, let's just say at one point, Karen S. Rodman, just herself individually, Karen S. Rodman owned the trust. Owned the property. She then went and she created a trust. So she did the paperwork that says, when I die, I want the property to go to this person. That's step number one. Step number two is she has to do a new deed and transfer the property from herself individually and make the trust the owner of the property. And that's the key thing where a lot of people mess up is you have the trust, you have the actual trust document, but you actually have to do a new deed and transfer the property into the trust so that the trust is now the owner of that property. And if that's done properly, the great thing about that is you can avoid probate. So Karen S. Rodman, TRS stands for trust, names, and it just happens to be another. Normally, I'm not sure why they showed up like this. Normally, it wouldn't show the beneficiary, but BEN stands for beneficiary. So the beneficiary in this case would be able to go to the county with the trust documents and automatically inherits the property without having to do the trust. And so that's trust. I'm gonna stop sharing. So trusts are really great tools to to avoid probate if done properly. And I think I've got some questions on trust. I always get a lot of questions on trust. People are very interested. So I'll answer a couple. We won't go too far into them, but yes, you can still claim homestead exemption if it's your primary residence. There's certain language that needs to be in the deed. There's certain language that needs to be in the trust. Generally, if you still have a mortgage on the property, you can still refinance, but that ends up being a question for the lender. That's not really in the law. It's fine with that, but it's really up to the lender. So there's some questions that you would want to know. But trust, again, that's just what I want kind of the takeaway from this is one of the ways to avoid the probate process is by putting the property into a trust. Or changing the deed. That's another way that you can avoid probate. Again, talking about last will and testament, not going to avoid the probate process. Let me just see where I was at. All right, it's going to be refinance. You can't claim homestead. Those are the All right, so I think we're good on that. Okay. All right, so let's assume that at this point, you or your attorney, it's determined that that probate's necessary, that we're going to have to go through the probate process in order to, let's just say, sell this property, right? Now what we want to figure out. Remember, I talked a little bit about the importance of identifying the personal representative. Reason being, we're going to come at this as if you're going to work with the seller, right? Because that's probably what you would prefer. The personal representative is the person who's going to pick the realtor who they're going to work with. So if there's, let's say, two sisters, and you're speaking with one of the sisters, and let's say they don't agree, and one of the sisters says, yeah, I want to use you as my realtor. And you say, great, okay, let's do it. You think you're ready to get started. But then the other sister, it turns out, chooses a different realtor, and that sister is going to be the personal representative. Well, you're kind of not going to be involved in that process, and you lose out on that deal. So you want to make sure from the get-go, from the very beginning, that you're working with the right person who you believe will be named as the personal representative. So yes, you can have more than one personal representative. Inez, yeah, you can have more than one representative. So a couple of questions that what I would suggest you ask, really two, 3 questions you want to ask when you go meet with this person. So let's say that you get a referral, you're going to have the listing presentation with them, and you're going to discuss, try to find out if they're going to be the representative. So first question that I would suggest asking is, ask them if there was a will. Ask them if the person who died did in fact have a will. Reason being, we talked about a will doesn't avoid probate, but it does say, it's usually, again, 99.9% of the time, it is going to list who they want to be their personal representative. So if you're speaking with John and John says, yeah, my mom had a will, and then we look at the will, and the will says that John's sister, Sarah, is going to be the representative, there's not much we can do, because the Florida law is very clear. Assuming it's a valid will and everything, the court is going to side with the will, and we're going to name Sally as the representative. So we want to find out, ask them if there was a will. The second thing we want to ask is, do they have a copy of it? Because I get a call every so often, probably once a month, where somebody will say, hey, listen, so-and-so died. I don't have a copy of the will, but they told me that there was a will. Well, there's no database for wills, unfortunately. So if they don't have a copy of it, there's very little I can do, because really, I could do a will, I could put it in this drawer back here, and when I die, that's where the will is. Nobody knows about it. So if they don't have a copy of it, there's very little that we can do, and just someone saying, "Oh yeah, he told me this," is not going to be good enough. We're going to need an actual copy of the will. So ask, was there a will, and do they have a copy of it? Can they get a copy of it? The second thing I'm probably going to want to recommend that you ask is, what's that person's relationship to the person who died? So was it their spouse? Is this their parents? Is this their sister? Who was it? And the reason is, if there is no will in the state of Florida, there's a priority over who's going to get what, or who's going to be the personal representative. So first it's the spouse, then it's the children, then it's the brothers and sisters, grandparents, and so on and so forth, until you get out to second, third, fourth, fifth cousins, or whoever it is. But in most cases, there's going to be a sibling, a child, a brother and sister. And so if you're speaking with the second and third cousin, even if that second cousin was living with the person who died, took care of the person who died, if if there are children, those children are going to be the people who have preference. And I've had this recently where a person contacted our office. It was her brother who passed away. The brother, they took care of the brother, they maintained the property, all of this stuff. And the brother has two children who he has nothing to do with. He hasn't seen them for 20 plus years. And I said, unfortunately, he didn't have a will. That property is going to go to the two children, regardless of whether or not you've been paying everything, maintaining it. Doesn't matter. Unfortunately, there's nothing I can do for you. So you want to find out, what the relationship was or is to the person who passed away, so we can find out if we think that person is going to be the personal representative. All right. So now talking a little bit, let's say that we are pretty sure this person is going to be the representative. Well, it's even if they have a will, it's not going to be enough that they have a will, they show you, they show me, and it says, oh yeah, I named this person as representative. We still have to go to court. I have to show a copy of the will to the judge. The judge has to sign a piece of paper that says this person is in fact the personal representative. All right. And the reason is because, and this is again, real life, situation, there might be two wills. Maybe we had a case where the first will was done in 1990, naming one person as the representative, and the second will was done about 15 years later, naming someone else as the representative. And we had to go to court and fight over this because the second will was done at or around the time that this lady had Alzheimer's. And so we argued and won successfully that second will was not valid. But if you had gone with that second will and that person, had hired you as the representative or as the realtor, you would kind of be out of luck because the first will is the one that's important. So just because a person does have a will, we still have to go to court and we get a piece of paper called Order Appointing Personal Representative. You probably don't need to know that, but it's a document that the judge says who the representative is. All right, so now we'll talk a little bit, kind of part two, we'll talk a little bit about the process. And for you all, what's important is, when can you sign the listing agreement? Who signs the listing agreement, which you all probably know now? How long does probate take? In all that sort of stuff. So the tricky situation, one of the first tricky situations is, let's say that a probate has not been started. Okay, this person, and this happens a lot. So someone will call my office. They'll say, listen, my mom just died, 2 weeks ago. She had this house. We want to sell the house. We want to get a realtor and all that stuff. But no probate's been started. They haven't hired a realtor. Maybe a lot of times they're living, maybe mom moved down here, but all the kids are back in, the Northeast, New York somewhere. Okay, great. Once we get started, it's going to take about 30 to 45 days, more or less, to have the personal representative appointed. Could be a little bit less, depending on the county, could be a little bit longer. But on average, it takes about 30 to 45 days to get the representative appointed. Nobody, in theory, can sign a listing agreement with any realtor until they are named as personal representative, because they don't have any authority. Now, in practice, though, if somebody comes to you the day their mom dies and they say, listen, I wanna hire you as my realtor, but they're not yet the personal representative, and you say, come back to me in 30 to 45 days after you've hired your attorney and you're named as the representative, chances are they're probably going to go hire another realtor. That's just the truth of it. So what I have somewhat suggested to realtors, and ask your broker, is you could have them sign a listing agreement that says their name, let's just say John Smith, as the proposed personal representative. They're not yet the personal representative. We believe they're going to be the personal representative. You cannot list the property. You can't put it on the MLS or do anything. In theory, this contract might not actually be valid, but it at least kind of consciously, subconsciously, ties them into you. And they hire you as it says, proposed personal representative. That's what the listing agreement says. Now we go to court, we get them named as the personal representative. Now we probably want to update the listing agreement, and it would say, John Smith as the personal representative, because now we have that piece of paper from the court. Now he's named as the personal representative. Once we get that piece of paper, once we get that document saying that he or she is the personal representative, now you all are free to list the property. As soon as we have that, day one, as soon as we have that document, at that point, now you can list the property. You can put it on the MLS. You can put, market the property, send mailers, put signs in the yard, whatever. But you really can't do anything until that person has been named as the representative. Okay. Now, though, that doesn't mean you can automatically sell it. And this is where probate can be sort of a headache for realtors and for people, because they, might not have the money to pay the association dues. They might not have the money to pay the mortgage or whatever the case may be, and they need to sell it quickly. Unfortunately, though, we have I'm going to give you all two scenarios of how long the probate takes. The first one is a little bit longer. And it depends on when the person died. So if the person died recently, meaning within 2 years, so we're in 2020, if the person died, from December 2018 through, December 2020, it's still going to take 30 to 45 days to get the personal representative named. Then we have to do what's called a creditor period, where we have to wait 90 days from that period. So we have to wait all of month 2, all of month 3, and all of month 4. And then in month 5, now we can sell the property. So if the person died recently, within 2 years, we have to get the representative appointed, and then we have to wait 90 days before we can sell the property. We can go under contract. You can go under contract during that 90-day period, but you won't be able to actually close, or we won't actually be able to get the sale approved if we need to, until that 90-day period is up. After that 90-day period, then we can ask the court to sell the property, or we can transfer the property to the new owners, to the owner's names, and then they can sell the property. So if the person died, again, within that 2-year window of when we start the probate, it's about a 5 to 6 month process from start to finish. And what we're doing during that 90-day period is, if the person died, let's say they owed money to, credit card companies, hospitals, whatever, we have to wait for them to file a claim. They have 90 days to file a claim in the probate case. And that's, a little bit advanced, and there's stuff that we do, and not all creditors can recuperate money from the sale or anything like that. It really depends. But we have to wait, regardless, we have to wait for that 90-day period to expire. So time frame, if the probate is happening within 2 years, I'd say it's probably gonna be about 6 month process, more or less. That's scenario number one. If the person died more than 2 years ago, so if in 2020 and the person died in 2015, and for whatever reason a probate was never done and the property was never transferred, We still have to wait the 30 to 45 days probably to get the personal representative appointed. But now we don't have to wait the 90 days. There's a kind of legal term, statute of limitations, where if the person died more than 2 years, no creditors can file a claim. So we don't have to wait that 90-day period. All we have to do is get the representative appointed, and then you all are free to, we transfer title and you all are free to sell the property. So if the person died more than 2 years ago, it's probably going to be about 2 to 3 months, more or less. That's a little bit about the process. If talking about creditors, if there are creditors, if it's a homestead property, the good thing about homestead property, so it's your primary residence, meaning that this is where the person lives full time, they get a tax exemption, all of those things. If a creditor files a claim, they cannot force the sale of that property to get any money that they're owed. So let's say Baptist Health, Baptist Hospital, Palmetto, Visa, American Express, whoever, let's say they're owed, $20,000. And the only thing that the person owned when they died was that piece of property, which was their homestead. Those creditors are not going to get anything. They can't force you to sell the property. They can't, when you close, you don't have to put that money in escrow so that those creditors get paid. The people inheriting the property don't have to pay if it's a homestead property. So that's one of the good things about it. If though, let's say that they owned the homestead property and they had $50,000 in a bank account, they could potentially come after the bank account and try to get repaid from that. Or if they had an investment property, maybe this was a vacation rental, that they've got in, Orlando or wherever, but it wasn't their homestead property, they could potentially try to get paid from the proceeds of that sale. But if it's a homestead property, which most of the time that's what it is, then they're not going to get reimbursed from any of that. So good question, Sarita. So what if the creditor did not appear during those first 3 months and you're under contract and now they want to get their debt paid? So what's happening is you're under contract and those creditors have that 90-day, 3-month period, and now they file a claim. Well, what we would do, what the attorney should do, is you can move to have their claim removed because they didn't file it within that 90-day period. So now it becomes a little bit of a legal battle, and there's some things that you'd have to do. So you'd want to try to have that claim removed because it wasn't filed in that 90-day creditor period. There's some things they can do, but again, and if it's the homestead property, I would say that they're not entitled to anything anyways, because it's the homestead property. So that's more or less. So then the contract, again, who's going to sign that? It's going to be the personal representative. The personal representative is the one who's going to sign that contract. One last thing on this is homestead property is a little bit different, because if it's a person's homestead, what we do in court is we go to the judge and we just ask the judge to transfer the property to the new owners. So if there's two brothers and the only asset is the homestead, what we do is we give a new piece of paper to the judge, which is basically a new deed. The judge signs that. We record that, saying that the two owners are the two brothers, and that's the new deed. At that point, if you're representing those brothers, they can sell the property as if it's any other normal sale. You don't have to come back to me, the attorney, to say, hey, here's the contract. Once we get that piece of paper from the judge and we record that and we say that those are the new owners and it was the homestead, it's outside of probate. There's nothing that we need to do. You guys can sell it like any other piece of real estate. If though it's not a homestead and you want to sell the property within probate for whatever reason, we might have to get the contract approved by the judge, and there's some other things that we have to do. Homestead is actually a lot easier for everybody because we don't have to get court approval. We just transfer title, and that's pretty much it. So in the case where it's investment property, the personal representative is the one who's going to sign all the contracts and everything. But if it's a homestead property, whoever the new owners are, those are all the people who are going to sign it. All right, so we're moving along a little bit quicker than normal, but I'm going to just talk briefly about, finding listings and all that sort of stuff. And let me just scroll up and see if there's any questions I missed. But if you all have any other questions about the process or anything like that, please throw it into the chat box. I'm just gonna check. All right, I think so. How much does it cost to put a property into a trust or change a deed? I can't really answer that. I'd have to, costs vary, so that's probably, somewhat dependent on the situation. If the court signed off on a personal representative and the house was sold, I'm not sure if that's a. Sorry, I can't really give you an answer on price. It really depends, because I don't do that necessarily. I don't always, we would do it as a package. I don't normally do standalone deeds. So, all right. So let's just talk a little bit about marketing for probate properties. So probably one of the best thing that you can do is build relationships with other probate attorneys, and that's more beneficial for you all because in most probates that we handle, it's going to own a piece of real estate. So we are going to refer that out to I would rather work with a realtor that I know, that I like, that I trust, that I know knows this process a little bit. So obviously, at the time of filming this, we're still kind of, social distancing and everything like that. So you're probably going to want to try to build relationships however you can with other probate attorneys. That's probably the best thing. Number two is you can go to, for example, probably a lot of you all might be Miami-Dade, Broward County. Go to the county's website, go to the property appraiser's website, and if you just type in a state of into the search box, you're going to get a list of properties that are owned by estates. Then from there, you could probably do some direct mailings or something like that to try to target, those potential beneficiaries, those potential heirs. A lot of times people don't even know that they have to go through probate. It happens all the time. I had a call yesterday with a prospective client. Their mom passed away, and same thing. They went to a title company, and the title company said that they needed to refer them to us, and they said, you've got to go through probate, and they don't even know that. So if you come to a prospective client and you explain to them a little bit about the probate process, you might be giving them some valuable information that they didn't even know about. So you can find that list. You can find a list, again, by just going to the county property appraiser's website and typing in a state of. You can also buy lists. You can buy leads that have the contact information of the personal representative, that has the contact information of the attorney handling the case. If you're going to go that route, I would probably say that you want to try to go after the personal representative, probably not the attorney. Just in my opinion, I don't think that's going to work that well. But if you go after the personal representative, you might have a little bit of luck there. And as always, you want to be somewhat respectful and pay attention, somewhat sympathetic, because again, in this case, somebody has probably just passed away. So you want to, understandably, this might be difficult for them. And understand, hey, sorry for your loss, et cetera, et cetera. So those are a couple ideas there that I think could potentially work for you. And so yes, Inez, how the property should be, how the document should be signed. Yes, Inez Ayala as personal representative of Mary Smith Estate. Probably what I would say, not a big deal, but if you want to be technical about it, you would probably say a personal representative of the estate of Mary Smith. That's probably what I would say there. Can you open up a restricted depository account and then the PR, not touch the money. Constantino, sounds like you've been through that restricted depository account. The short answer is no. The law, most courts are not going to allow you to sell the property, even if you put the money into a restricted account for that 90-day period. They're not going to, that used to happen a little bit in the past. The judges were a little bit more relaxed on that, even though the money's not getting touched. But that's becoming, almost impossible to do that now. Let's see. I don't know. Yeah, so some technical questions here that could be difficult to answer online. I'll end with this because I know a lot of people out there do deal with LLCs and for investors. Generally speaking, an LLC is not going to avoid probate. So a lot of times we have investors, you have a client in Argentina, they purchased a property, in the early 90s, they put it in the name of the LLC, and now that owner of the LLC has passed away. Chances are, if they did not do an operating agreement, if they did not put the LLC into a trust, which is one thing that you can do, the family back in Argentina is going to have to do a probate in order to put the property into their name. So what I recommend to, if you're working with investors or, maybe you own properties in an LLC yourself, it's worth a conversation with an estate attorney, your CPA. I always like to bring in a CPA just to come up with a plan, because having a property just in an LLC alone, unless you have some supporting documents or you put that into a trust, it's probably not going to avoid probate. But again, technical conversation, more longer than we, probably have time for here, and easy to explain. Yes, you can abbreviate PR and EST. That's fine. It is a lot of information to put on the contract. So if you're filling that out, chances are, you're filling out the FAR form online, and you're trying to put in, Mary Smith as personal representative of the estate of, whatever. It's probably going to be too long. So yeah, abbreviations are fine. If the deceased was under a guardianship, we do the same thing. I'd have to learn a little bit more. I'm not sure I understand, but guardianships are a little bit more complicated, and kind of I'd have to learn more about the situation. So, well, I think that's a good place to stop. So again, if you want to, if you have questions, we've got a lot of great resources on our website. Just go to www.probatefirm.com. That's the best way to get in contact with us. Or again, we've got a bunch of free books and information on there that you can read. So great speaking with you all. Hope you all stay safe. Happy holidays. And like I said, I will, well, let me stop this.